Okay, all right. So thank you for being here for our February meeting. We have a number of regrets, as you can tell, with the number of people on the site. So Francois and Howard and Matthew will not be joining us. I didn't receive anything from Matthew this month, but I believe his message from last month was that he's teaching at this time for this semester. So we're just going to assume that's why he's not here, and that's perfectly fine. Okay, so we have the agenda and the minutes that were forwarded a couple of days ago. So can I have a mover to approve the agenda as circulated? Irving and a seconder, Brendan. Thank you. All in favor? Great, thank you. Likewise, the minutes prepared by Peter. Can I have a mover to accept the January 10th minutes? Stefan, seconder. Irving, thank you. All those in favor? Carried. Thanks very much. All right, guys, let's move down to item 4 on the agenda. Andrea just joined us. Thank you, Andrea. So we'll move down to item 4. The first item, which is what we had from last month, was a note from Peter in response to the potential for an Alberta Police Service. Peter was going to draft something for us. Have you had time to get to that, Peter?
It's halfway drafted. I got a notification that they didn't need it for the justice report at the time that they originally said, which is why I was able to commit at that point. And so I don't have to have it ready until springtime, later on in the spring. I will actually, as I said, I'm about halfway through. I just put it down once I found I didn't have to have it in. So I will get that finished off and then sent in so it can be distributed. What I've essentially had to do was abridge and précis a 5,500 word essay down to 1,500 words, which has not been fun. The other thing I was thinking, if I can actually cut that much out, then I was far too verbose in the first place, but that's something I'll work on. But no, I will get it out definitely before the next meeting. It'll be shipped over to Miles and for distribution.
Oh, good. Thanks, Peter. Appreciate that. Okay, the next item is a continuation of the first time we noticed this in our meeting in January, dealing with the December killing of an OPP officer. There's been a lot of activity on this since then. I included an article from the Globe at the time, basically indicating that there is a movement, including a letter from all the premiers of the provinces and territories seeking to have criminal justice reform in the area of bail, particularly as it involves violent offenders. The proposal being that a reverse onus be put in place in that regard. And since then, on February the 9th, I didn't put this in the agenda, I apologize. There was an article in the Ottawa Citizen. The title is "Recent Violent Crime Caused Notable Shift in Public View of Criminal Justice, Lametti." And so what the article goes on to basically say is that Justice Lametti, who's the Minister of Justice, is now indicating that the federal government is going to take a serious look at reform and I presume it deals with bail and this particular issue to address what has become a moral panic, essentially, in this regard. So a lot of scholars and lawyers don't think a change is required. There was the provisions in the criminal code dealing with bail, 510 to 515, give lots of powers to, whether it's a JP in Ontario or a judge elsewhere, hearing bail applications, lots of powers to put conditions in place that curtails the activities of those who committed whatever crimes there are that come before them. The issue, of course, always is that at a bail hearing, the presumption of innocence is still at play. And in the case of the killing in December of the OPP, the perpetrator, the alleged perpetrator of the murder, was on bail. Did have conditions in place, and in fact had breached those conditions, and the local police authority hadn't picked him up as a function of those breaches, and that seemed to be, from my perspective, that was the heart of the issue. Not that there weren't conditions in place, but that the conditions were breached and not followed up on. Anybody have anything they want to add to this particular issue? I mean, it may be something that we may want to make a submission to when it gets to that point. A private member's bill has been put forward dealing with this. We're going to talk about it later in the bills part of the PRC meeting, dealing with changing the rules regarding bail. Anybody want to add to this at this point? No? Okay. Right, that's fine. So let's keep an eye on it. If there is an opportunity for submissions on this, which is going to require obviously an amendment to the criminal code, then we should probably come back and talk about it and deciding whether we want to make our position known for the purposes of committee work. Okay, so let's leave it at that. Next item, this brought to our attention by Irving. It's Stats Canada are requesting feedback on an attached report, and we've attached it to the PRC agenda and recommendations. Irving, did you want to mention that? And Kyle also indicated he may be interested in participating.
Yeah, if you've had a chance to have a look at it, I think it's about 6 recommendations. And from my perspective, they're pretty much motherhood kinds of statements and so on. I'm hoping Kyle can have a look at it. I don't have particular expertise in this area. I'm not sure who does, but Kyle had done quite a bit of inputting to the original document, you recall. That was like, I think it was September 2021. And Howard had added some stuff, and I did some wordsmithing as well. We sent it off. I was part of a virtual meeting. I think I was one of 3 people who were actually talking to the StatsCan. I think it was a consultant. I'm not certain. I don't know if I recall exactly. I think it was a consultant. And so we finally saw something come out a few months ago. And then just this past week, we were offered the opportunity to do another level of feedback, if you like. So I've shared it with yourself, with Howard, and with Kyle, and I hope Kyle can add something on top of that. Peter, I don't know from your perspective, I think I sent it to you as well, because it primarily calls on the police to do certain things differently. And as well, there's a whole issue which we had in, recall the study we did, we had the 3 researchers rather from University of Toronto looking at the whole issue of police use of force. And one of the major findings was there's a lack of standardized collection of data, right? So you can't compare one police agency with another. And that's just on a macro level. When you get down to the Indigenous level, specifically, you're looking at the recommendation, and we talked about this when we had our virtual meeting, is how do you determine who is and who isn't Aboriginal? So it's self-reporting as well as, you know, the police officers reporting and that kind of stuff. So it's a lot to it. I'm not sure necessarily at this point in time that the report that I've shared really advances the agenda too far. But Peter, you have more expertise certainly on the police side.
Pardon me. I just wanted to say 2 things. Number one, I actually forwarded both the link and a copy of the report. I sit on a group called the City of Calgary Transit Use of Force Committee. It's a committee of council, and we review all the use of force incidences, not even allegations of wrongdoing, just incidences themselves. This has been an issue for us for a long time. And I really did support I do support the recommendations that were in that document you send out, Irving. Yeah, a bit of motherhood. That being said, sure, a lot better than what we have. And especially what I really liked was both the actual self-declared background of the individual or the perception background by the officer. And I think that can be very easily worked out. And tick off the right box. My perception, here's what he said he is, or she. And I think it's a great idea. I really do. I do note that police were, and in fact, in the earlier research, and I can never pronounce his name. It was in there, double-barreled name. Well, anyways, he had noted that originally the police had been very hesitant to back this, and now and they still are to some degree. Now they've changed over, and actually the various communities themselves are very much in favor of having this data collected. And it's not so much to put blame, It's to actually figure out where we need to be putting community resources to help those communities and or those people in general. So yeah, I think it's a really good factor. I haven't heard any negatives directly out of Alberta policing. I'm sure there will be some somewhere along the way, but I think it's a well worthwhile project to move forward with, and especially that it's backed by the Canadian Association of Chiefs of Police.
But Peter, do you actually see it going anywhere? I mean,
yeah, I actually I do. In fact, a policy recommendation for Calgary City Council will be coming from our committee, which is that they should be collecting disaggregated data on racial data and using that as part of their analysis for areas of where there's problem areas, both the analysis of the actual problems, and John Winterdyke will know about this, whether it's at Sunnyside Station or down at Chinook, and who are involved, because these sort of anecdotal information you get from just reviewing all these cases is that there's a very strong or very high proportion of individuals who are Indigenous and or homeless, which could be a whole raft of different people. But that comes out. So my point being that information becomes very useful in saying, hey, here's the problem areas. Here are the individuals involved. What can we do in the community, especially the Indigenous urban community, to take care of this issue and problem? So I see that as being a positive, not as a negative.
Okay.
Thanks, Peter. Thanks, Irving. Okay, so I'll make a note that we'll call on Kyle next meeting and to take it from there. Okay, business arising. So the updates on the justice-related committees. The first committee is Justice and Human Rights. In the comments, that's Howard. He's away, so we won't have anything from Howard today. Secondly, we have Public Safety and National Security in the Commons, and that's Rob. And Rob sent me an email. I'll just read for the record what he has to say about that. So as for this committee, I reviewed its recent activities on the Commons website and noted that 2 meetings took place, neither with evidence available as of today. One was regarding Canada's security posture in relation to Russia and involved the resumption of consideration of a draft report. The second involved an appearance by the correctional investigator. With respect to the latter, the purpose was to discuss the OCI's report released several months ago. Similar to the actual report, I suspect that the discussion centered around the multiple recommendations made regarding Indigenous offenders and Black offenders, and to some extent women offenders. The report also made recommendations regarding several smaller individual issues, such as having safety belts in inmate transport vehicles. In addition, this committee will meet on February the 14th, being today, to discuss amendments to Bill C-21. Okay, so that's it from Rob, so thanks for that. Next committee is Legal and Constitutional Affairs. Brendan, you're up.
Yeah, thanks, Miles. So the committees had four meetings since our last PRC meeting. Chronologically, the first 2 were discussing the changes to Section 33.1 of the Criminal Code. Another was on Bill C-233, which is an act to amend the Criminal Code and the Judges Act, in bracket violence against an intimate partner. They also did a clause-by-clause consideration of that bill in the 4th meeting. And then also in that 4th meeting, they began discussing Senator Kim Pate's bill C-212. Sorry, that's not Kim Pate. S-212, I believe it is. I wrote that down wrong. Apologize. So I'll just start with Section 33.1, the discussions that were had on that. The committee began discussing this in November or December. There's different points of view. They met with several women's legal groups and other women's victims advocates. They also met with various law professors. And also the recently appointed victims ombudsperson, Ben Roebuck, who some of you may be familiar with from Ottawa. So the committee has to table a report by March 10th on this change. It's interesting. There's concerns that this bill will do nothing, that this change, I think we're all sort of on the same page. I think we've discussed a little bit, but there's concerns that this bill will either do nothing, and that women will continue to be victimized, and it really won't protect them. There's also another point of view that actually the changes will render the defense of self-intoxication so widely available that it will actually put women at risk. That was suggested by some witnesses, but not all witnesses are necessarily convinced that it will increase violence. But the idea is because with this new change in the foreseeability of causing harm to another person, that someone can say, oh, I've been doing drugs, or I've been doing this and this forever, and this has never happened before. How could I have known? Otherwise, someone will say, I've never done it before. How would I know that harm was reasonable foreseeability? There's also talk of a more subjective view of the foreseeability using like a reasonable person test. I hope I got the legal terms there correct. I'm not a lawyer, as you all know. There were some suggestions on how to fix this issue, and one suggestion was to either remove that subsection in the new section 33.1, which requires that harm be reasonably foreseeable. A second suggestion was perhaps saying that it's not a reasonable foreseeability of harm, but rather a reasonable foreseeability of loss of control. So those were some suggestions. Importantly, I think one person who a big name for us, someone who was Kent Roach, testified on this, and more or less didn't think that there was more advocating for a wait and see approach, and was actually pretty supportive of the legal change. So some witnesses, though, are a little worried about this new change. Some are advocating for that wait and see attitude. Let's see if we can get some data on this. And of course, victims advocates are saying, well, a wait and see attitude is just waiting for more victims. How can we do that? So that obviously, as you all know, it's a really tricky issue. So one thing, let me just see. One case that was really important, actually, that was brought up because I think it's a very recent case. I think it was February 1st or 2nd where the decision was released. Because again, this whole idea that a study will be done on the changes done to section 33.1 was that we don't have enough data, and these cases are so rare that we will rarely that they'll rarely come up, and that's why we need 3 to 5 years, let's say, for a review. However, a case from the BC Supreme Court, I'm not sure if anybody has read the decision. It was R versus Perignon. It was essentially a case of a man who was on various opioids, was sleep deprived, mixed with a little bit of alcohol, but not very much, especially considering the amount of alcohol that he normally drank. Unfortunately, stabbed his wife in the back. She did not die, thankfully, but he was acquitted on the grounds of self-intoxication akin to automatism. So that was brought up at the committee, and that was quite contentious because some senators were saying, oh, look, we already have a case of this happening. Though, of course, the new change wasn't quite was not in play for this specific case, just because the law had only so recently changed, and the offense actually took place in, I believe, 2017 or 18, so well before the change was made. But it was making the point that women are frequently the victims of these kinds of offenses, and that this defense of self-intoxication is frequently used in the context of intimate partner violence. One thing I just want to bring up, it's an observation that I had while watching the committee meetings, and it's something that I don't think I haven't really seen brought up, and I'm very curious. Maybe you all won't have any comments on it, maybe you will, but if I recall correctly, the Supreme Court and I believe the Justice Minister were saying that that simply being so drunk to a certain level would not allow somebody to avail themselves of this new provision. And they're saying it's frequently when people are mixing medications or drugs with alcohol. And it's frequently, at least in my reading of the situation, that's frequently brought up as a mitigating factor that, oh, it's only in those rare cases where people are mixing drugs and things of that nature. I am a little afraid that the Supreme Court is underestimating how much people mix drugs, how many people are on medications. If you look at the rates of mental health, people are on so many types of medications, so many people drink. So I think when they try to portray this mixing of drugs as an exceptional circumstance, it's really not exceptional, and that's precisely what happened in this R versus Perignon case. It was opioids for a pain disorder, and that was allegedly mixed with some changing medication dosage as well, which is again very common, and a little bit of alcohol. And so I personally am a little bit afraid of that, and I think that it's being underestimated just how much people are actually mixing alcohols with various other substances, whether they're legal or not. So that's what I have to say on section 33.1. The other two bills that the committee was looking at are quite short. So Bill C-233, I believe it's a private member's bill from the House of Commons. It's actually sponsored by the member of Parliament, Andrew Dillon, who's a Quebec MP. It has two aims, basically to increase use of electronic monitoring and increase training for judges on the subject of intimate partner violence, with particular concern to this idea of coercive control. And so there are very small, it's a very small bill. It's essentially that training be made available for judges, but it does not direct them that they have to take it, just that this training on this specific topic in intimate partner violence be made available to judges, and that the use of electronic monitoring be increased. It mirrors Bill S-205, which was looked at in the fall, which was Senator Boisvenu's bill about increasing the use of electronic monitoring. Of course, there's concerns about when we increase electronic monitoring, the cost of it. Is it offering false hope? Now, of course, most victims advocates are saying, well, the hope isn't false because it does offer reassurance. But I won't rehash all those arguments again, just because it's so similar to Bill S-205 we looked at previously. The clause by clause consideration was made. There's two clauses, I believe, or two or three, all accepted, no change. And that was where it was left off. Finally, Bill S-212 was looked at, and this was, again, it's Senator Kim Pate's bill on record suspensions. They had a single witness. Again, it was Ben Roebuck, the ombudsperson for victims. And essentially the bill would create automatic record suspensions for summary offenses, and a tiered approach for different offenses, and how those records would be treated. I believe there are carve-outs for sexual offenses and Schedule 1 offenses, so they're not necessarily automatic. There was also one big item that was discussed was making housing a human right, and that cannot be discriminated against based on one's criminal history. If they have a record suspension, they cannot be discriminated against in the context of housing. Of course, the witness Ben Roebuck was very supportive of this bill, but that's where we left off for Bill S-212, and I expect there'll be more meetings on the subject. And that's everything for me.
Oh, thanks, Brendan. Very, very comprehensive as always. Any questions or comments for Brendan? Good stuff. Thank you. The last committee is the Senate Committee on Human Rights. It's met twice. It's fine. It's met twice in the last week. I confess I'm still working my way through the video of the meetings. So far, all I can see is that there's the discussion as a follow-up to the tabling of its bill in December, dealing with basically eliminating Canadian barriers to humanitarian relief. I went through that last meeting and talked about what the barriers are, particularly in Afghanistan and the concerns of the Canadian Red Cross. So I will finish watching the video and then whatever comes up and have a full report for next month, if that's okay. All right, guys. Further business arising, items B and D are waiting briefs. Item E, invitation letter for consultation on facial recognition guidance. Peter and Lynn are still preparing a report in that regard.
Yeah, I haven't been able to get in touch with Lynn, or she with me, since the last meeting.
Okay, then I'll just keep that on the agenda. Thank you. Item H, alternatives to incarceration, letters to the minister. Again, that's been on the agenda for quite a while. Matthew and Kyle are preparing a letter, so we'll return to that next month. And so the next item is the item that I have carriage of. It's proposal regarding provincial support for including criminal records as a ground of discrimination in all human rights codes in a uniform fashion across the country. Peter accelerated the minutes for us in that regard, which we then turned over to Irving, and Irving did circulate this to the individual provincial associations. So maybe you can just bring us update on that, Irving.
I've heard nothing back for any of them. I guess it's not a burning issue right now. I don't know. Have you heard anything in Alberta, Peter? I did share it with, what's his name? I forget.
Rich.
Richard, yeah.
Yeah, I haven't heard anything. In fact, interestingly enough, normally he passes all that stuff on to me. And I haven't seen anything, so I'll get on his case. And actually, we have a meeting on Friday. I'll bring it up on the, at our, what's it called, monthly board meeting.
Yeah, I sent, sorry, Peter, I sent it to Ontario, I sent it to Manitoba and Nova Scotia, and BC. I haven't heard anything back at all.
Well, thank you for doing that, Irving. It's obviously it's not front of mind for anybody. I will for next meeting. I'll prepare a report for the PRC with my recommendations, and then we can talk about that.
I don't know how we jump it to the federal level without. I mean, it's primarily, I think, a provincial responsibility. Without having really significant input from the provincial affiliates, I don't know where we take it, but.
Well, I mean, I guess what we can do is, again, I'll generate the report. I'll have recommendations. We can discuss the recommendations, adopt them or not, or change them, and what have you. And whatever we come up with at PRC with respect to our position, then we'd circulate that, back to all the associations to get some more input or any input. So
I hope we get something. Yes.
Hope so. But thank you.
Thank you.
All right, bills under consideration. So firstly, Bill C9, amending the Judges Act. It's simply moved to second reading since our last meeting on December 13th, then January. Bill C21, an act to amend the acts regarding firearms. This is still in committee. You probably would have seen in the news. There was, previous to today, there was a amendment put forward, a 400 some odd page amendment put forward at committee that was going to add to the list of prohibited weapons a number of what are in fact assault weapons, but was argued by a number of groups, including farming groups and First Nations, that the particular weapons, some of the weapons there were used for hunting and weren't necessarily assault weapons, although they had the assault nature of them. So having said that, the federal government came back and said they were rescinding or pulling off the amendment for committee. They indicated in a rather contrite manner that they just hadn't thought it through. So that's obviously a political decision to a great degree. Anybody have any comments on this issue?
It's going to remain a hot button issue for the province of Alberta and probably the prairies as well. It just is. And sounding trite, yes, I don't think they thought this through very well, other than for political reasons from the very beginning. But that's just my comment.
I'm not sure they thought it through from a political strategy either, Peter.
It was never. It was always going to be a no-win, no matter what they do, right?
Yeah, but they tilted it in their disfavor, right? That's the issue. I
agree. Okay, thank you. Bill C39 was introduced after our last meeting. His first reading was on February the 2nd. It's now at second reading. This was an act to amend the criminal code regarding medical assistance in dying. So what it basically, the act is to do is to delay until March 17th, 2024, the repeal of the exclusion for eligibility for receiving medical assistance in dying in circumstances where the sole underlying medical condition identified in support of the request is a mental illness. Okay, so they pulled back on that as well.
And again, from an Alberta standpoint, that's actually drawn a fair bit of press out here, and not from the political side, but from the practitioners themselves, the doctors, and those who are dealing with mental health, and so that's still a hot button issue, at least in this part of the country.
Yeah, very good. Thank you. Okay, private member bills in the Commons. So I'll take us through to, and these are, yeah, private members. So Bill C-233 on page 5, an act to amend the Criminal Code and the Judges Act, violence against intimate partners. It's in committee. And then we have no change on most of the other bills. Of course, we've only been sitting for the last week or so after the Christmas break. Bill C-291, which is on page 7, an act to amend the code to make consequential amendments regarding child sexual abuse material. So it's basically made its way through the Commons and had first reading in the Senate on February the 2nd. Okay, so it's moving forward. Bill C-311 at the bottom of that page, an act to amend the criminal code, again, violence against pregnant women. So that this was introduced on January 31st. So this bill amends the code to specify that knowingly assaulting a pregnant woman and causing physical or emotional harm to a pregnant woman are to be considered aggravating circumstances at sentencing. Okay. And we've had, and likewise, Bill C-13, and this is what I mentioned earlier. Again, it's a private member's bill, but it deals with detention and custody, so bail. And so this is the private member's bill that was basically put forward to increase the burden that an accused must satisfy in certain exceptional circumstances to establish that their detention and custody is not justified, and that is a reverse onus in the bail process. So that was its first reading was last week on February the 9th. So that, and from what I read, when I indicated earlier from Justice Lametti, that's going to turn itself into a government bill in relatively short order, I would think. In the Senate, we have no Senate government bills on the agenda. And for private member bills, there's been very little change. Actually, there's been no change in any private member bills in the Senate since our last meeting, unless Brendan, did you have changes to any of these private member bills in your?
I'm just trying to look through them. I think S-205, I think that might be at second reading in the Senate. I think it's out of committee. I'd have to double check that one.
Yeah, we had that. We already have that at second reading.
Oh, sorry, my mistake. I didn't see that.
You want anything else?
I don't see anything immediate. I'll take a quick look afterwards, just to double check, but I think this is all right. Like I said the S2, the one I just presented on, that one, like I said, they just went through clause by clause, and I imagine it will be going back in soon. But it was, yeah. See, oh, sorry, that's a Commons bill. Yeah, no, I think this is all right. Miles, sorry about that.
Thanks, Brendan. Okay, everybody, that's it for today's meeting. It's rather a quick one, so we can all run out and buy cards and candy and flowers. So happy to have Valentine's Day, everybody. Any further questions or comments for the group as a whole?
Just one thing, which and John may have thought it was interesting too. The legal association out here in Alberta, they had a compulsory Indigenous training for to stay registered with the society. You had to have this. There was some people took umbrance about that. They ended up having a vote, and it was actually quite interesting. The although it passed, with a great number of people agreeing to carrying on with the training, I think what was interesting more was the number of people who were against it. And so I thought that was just something that, again, that may be just a Western thing, but I just thought it was quite telling that we would actually have our law society go to that extent as to have a vote among all the lawyers to get that passed.
So it was the Law Society of Alberta then.
Yeah, that's right.
That's very interesting.
What was the split, give or take? Do you recall?
It was overwhelmingly in favor of carrying on with the it's 1,000 and some odd, but there was I think there was I haven't got the numbers. It was just in the newspaper recently, or in the news recently, but there was enough to say, hey, wait a second, this isn't just the odd kook from Coots, Alberta. This is a number of people, and so I just thought it was an interesting take. Especially seeing that all the arguments about judges, and compulsory training or not compulsory training and things of that nature. And so I just thought, yeah, it was interesting.
Thanks, Peter. Thank you for bringing that to our attention. Anything else? Yeah. Oh, Irving?
Miles, just add one thing. This is John Howard Society Week, and they're having a number of podcasts. It started yesterday. It's at 1:00. I sent the notice to Howard. He put in the newsletter. Everybody should have it. So this afternoon, starting at 1:00, it's going to be talking about access to correctional information, I think is the topic. So if you have the time, you could click on the link that's in the newsletter. If you don't have it handy, I can send it out to you in a couple of minutes.
Sure.
Could you send that to me, please? Hi, could you send that to me, please, Irving?
Sure.
Irving, send it to me and I'll send it to everybody.
Yeah,
Great,
I'll do
thank you.
that as soon as we hang up here.
I appreciate
Thank you. Thank you.
Yeah, that's great.
Super. We'll see you all in March.
Okay, guys, thank you very
All
much.
right.
Thanks, Miles.
Take care, everybody.
Bye.
Yeah,
Stay healthy.
bye-bye.
Bye-bye.
All right. Bye-bye.